All right, everybody. Well, we got it working finally, I believe. Hopefully, someone can confirm for me. Hey, folks. All right, everybody. Sure enough. All right, I heard myself. There we go. Welcome, everybody, to today's Law Self-Defense Advanced Class Q&A extended format. So for those of you who don't know, presumably you all know, that's why you're here. But this past Saturday, we had one of our very rare Law Self-Defense advanced classes, our full-day class on self-defense law, use of force law. We cover just an enormous breadth of content, um, including providing a reality-based understanding of how the legal system actually works, talking in depth about the 5 elements of self-defense, those, of course, being innocence, imminence, proportionality, avoidance, and reasonableness, the elements that are required for a valid claim of self-defense. The good news is there's not 500 elements or even 50 elements. There's only up to 5, often not even that many. So this need not be rocket science, but unless you know what those elements are, pretty hard to make sure that you're staying within the legal boundaries. Talk about the consequences of not being inside the legal boundaries, what attracts prosecutors to charge and drag people to trial, and what discourages from doing that. We talked about defense of others, defense of property. We talked about um, consciousness of guilt evidence. We talked about self-defense immunity. We talked about, at length, interacting with the police in the aftermath of a use of force event. We spent almost an hour on that topic alone. We talk about integrating all that knowledge into you building your own legally sound self-defense strategy, because it's slightly different for all of us. We all draw our lines in different places. And by the way, we don't tell folks where to draw their lines, when to use force or not use force. We don't tell people what to do here at Law Self-Defense. We only try to help you make an informed decision about where you choose to draw your lines. Some people are more amenable to legal risk than others, more amenable to physical risk than others. Everybody's different. We can only help you make an informed decision. So we had that class this past Saturday. We only do that class. The last time we did the class was almost 2 years ago, folks. So we only do it usually every year or two. If you missed it, I'm sorry about that. Maybe in the fall we'll do another one. It depends on the kind of interest we get. It's a pretty long day for me on a weekend, so I tend not to do those classes any more often than I have to. Now, we had hundreds of questions submitted during that class on Saturday. I actually, after the content portion of the class, I spent about an hour and a half answering questions that had been submitted, and I only got about a third of the way through the question. So we still have hundreds more to go. That's the purpose of today's show. I had promised the students that I would record answers to those unanswered questions and share them with the students. And of course, we'll still do that. We sent them an email so they know this show is taking place. They can either watch this live or we'll provide them with a recording after the fact. But we thought as long as I was going to spend an hour or two answering all these questions, it might be fun to do it as a live stream so all of you could get some exposure to how we work, what we do in this context. And of course, if you'd like to submit your own questions during the live stream, feel free to do that. We'll only be answering the super chat questions though, because we'll get thousands of comments and I don't have time to read through them all. So where to begin? Oh yes. Now, obviously I can't reteach Saturday's class in the course of a single live stream. I don't intend to do that. So a lot of my answers are going to be provided in the context of the students who took the class. This Q&A is really for them. So often I'll be saying, as we discussed in the class. If you weren't in the class, I guess you won't have that context. But if you'd like to have that context, of course, the live class is over, but we do have, of course, we have the same content, actually more content in a online streamed version of the class, the one that we normally sell when we're not doing a live class. And we have it set up as a bundle. So after the Rittenhouse acquittal, we had actually set up a Rittenhouse bundle of our 4 best-selling courses. We put that on sale after the Rittenhouse acquittal for about a week. We're reviving that sale for one day, today only. So I have a little image to pop up for that. So, whoop, not that one, this one. So this is the Rittenhouse bundle. Let me get rid of that. This is the Rittenhouse bundle that we put up after his acquittal. We've revived it for today only. So these are our 4 best-selling courses. The advanced class, which is what we taught this past Saturday. In the image here, by the way, you see these pictures of DVD collections. This bundle is just online. We're only using those images so you can get a sense of what the classes are like. So you won't be getting a DVD in the mail through this bundle. It'll be instant access, online streamed courses. But it's our advanced class, which is about more than 8 hours of content. The state-specific supplement of your choice. So there'll be a pull-down list. You choose your state. You get your state-specific statutes, jury instructions, case law aligned to the major chapters of the advanced class. You get our defensive property course, a dedicated course on defensive property, and you get our course on riots, looting, and arson. That's not how to commit riot, looting, and arson. That's how to defend against riot, looting, and arson. The dynamics there are a bit different than the normal traditional self-defense scenario. So if you're interested in that, you can get that bundle today only at lawofselfdefense.com/bundle. Normally, these 4 courses, if you bought them individually, would be about $500. They're $200 as this bundle today. So you save yourself more than half, save yourself $300 if you'd like to get these courses in this bundle today. All right. With that out of the way, I do want to mention before we jump into the questions too, another matter, and that is you've probably all heard that the McMichaels and Roddy Bryan were sentenced last week for the death of Ahmaud Arbery, and they were all sentenced to life in prison. The McMichaels, Travis and Greg, were sentenced to life in prison plus 20 years without possibility of parole. And Roddy Bryan was sentenced to life in prison plus 20 years with possibility of parole. So he may be eligible for parole in something like 30 years. I think he's 52 right now. So when he's 82, he may be eligible for parole. And I'm not today, don't want to argue the merits of these convictions or these sentences. I just want to point out that the convictions are real. The sentences are real. And if you put these gentlemen on a truth detector, a lie detector machine, and ask them if they thought, now they may be legally mistaken, so their convictions may be just, but if they thought they were acting lawfully, that they were making a lawful citizen's arrest, I bet they would tell you that they thought that was true, and that the lie detector test would affirm that they believe that to be true. So my point is that people can do things they think are lawful, they think are social good, arresting someone that they think is committing repetitive burglaries in their community, and the legal system can decide otherwise and put you in jail for life plus 20 without possibility of parole. That's a legitimate outcome. When I say that there's never a 0% risk of being convicted at trial, well, this is one possible outcome. No matter how lawful you think your conduct is, no matter how morally beneficial, socially positive your conduct is, making a citizen's arrest of someone you believe to be a felon, coming to the defense of some third party, a stranger, a woman being raped on a subway car, as was in the headlines not very long ago. If those things go sideways for you and you get targeted by the legal system, one of the outcomes you're looking at, aside, of course, from actually dying yourself in the physical confrontation, is getting convicted and doing life plus 20 without possibility of early release. And there's a consequence to our legal system operating in that way. And that is when you read in the newspaper that people just stood around and watched a woman get raped in a subway car, well, perhaps those people who are just standing around are actually making an informed decision. Maybe they have children to raise. Maybe they have a life to live. Maybe they're deciding, you know what? I'm sorry this is happening to that woman, but I'm not doing this to her, and I'm not willing to risk life in prison plus 20 years without possibility of early release to get involved. I'm not doing it. And by the way, much the same is true, may be true in terms of law enforcement. A lot of cops are looking at what happened to Kim Potter and saying, man, she looks to me like she just made a mistake. Maybe negligent, but she didn't know she had a gun in her hand. No one claims that she knew she had a gun in her hand. She made a mistake, and now she's going to spend a decade, 2 decades in prison on reckless manslaughter. I mean, Derek Chauvin got convicted of a similar charge and sentenced to 22 years, 22 and a half years. So what's Kim Potter going to get at her sentencing? It wouldn't surprise me if she got 20 years too. And a lot of cops are going to say, you know what? I mean, unless I see someone being murdered, I'm not going to be proactive, because I've been put on notice that if I make a mistake I could spend the next 20 years in prison, or at least be put to the trial. And, you know, it's always generally been good advice that if you want to live a safer life, then live in a safer community, in a safer neighborhood, right? If you live in a place with lots of crime and lots of violence, you're likely to be a victim of crime and violence. And I do advise that. I certainly follow that advice myself. But you may be thinking, hey, if I live in a community that's relatively safe and most people are law abiding and our cops and our prosecutors are, you know, favor law-abiding people. They would take a kind view of someone who acted in self-defense or came to the defense of another person or engaged in what they believed was a lawful citizen's arrest. I'm probably not going to get prosecuted by my, you know, arrested, charged by my local police and prosecuted by my local prosecutor. And that could be true. But as we see in many of these cases, the authorities that drag you to trial and get you convicted may very well not be your local prosecutors, right? In the Ahmaud Arbery case, the local prosecutor, the first one, actually wrote a memo saying this looked lawful to him, looked like a lawful citizen's arrest and lawful self-defense. He actually wrote a letter. And then he recused himself from the case because he had some personal connection. And then the next prosecutor recused himself, and the next prosecutor recused herself. And finally, when all the local prosecutors were basically off the table and the political heat around the case began to energize after the video was released, the state stepped in. And the prosecutors who actually were in trial and got the McMichaels and William convicted and sentenced to life in prison plus 20 years, those were not local Brunswick prosecutors. Those were prosecutors brought in from the Atlanta area who obviously have a very different view of this kind of conduct than did the local prosecutors. The same thing happened in the George Zimmerman case. His local prosecutor actually quit rather than bring charges against George Zimmerman because it was obviously self-defense. There was no evidence inconsistent with self-defense in the Zimmerman case. When the prosecutor knows he's going to be obliged to disprove self-defense beyond a reasonable doubt at trial, so what happened? That prosecutor ended up resigning. The state took over. They brought in Angela Corey from a different judicial district from around Jacksonville. Again, it's much like bringing in someone from around the Atlanta area. Very different view of the facts and the law in this case. Charged George Zimmerman with second-degree malice murder. Never had any realistic chance of getting a conviction on that charge. Had to lie, had to hide evidence in order even to get Zimmerman into trial in the first place. With, of course, the help of the media, which always helps the prosecution in these cases. Speaking truth to power, my butt. But she wasn't the local prosecutor either. So just because you live in a community where you get along with your cops, you may even know your prosecutor. It would be unusual, but maybe you do. Maybe you've met him at some town event, think he's a nice guy, not the kind of person who would aggressively go after someone who appears to have acted in self-defense. He may not be in charge of your case. Someone else may be put in that courtroom to prosecute you. And their political interests and motivations may be completely different and contrary to those of the local prosecutor that you may well have voted for, because that's the kind of prosecutor you wanted in your jurisdiction. And it's not up to you. Someone else is making those decisions. So if you're feeling like you're less inclined to involve yourself in violent events, come to the defense of another, make a citizen's arrest, those may be prudent decisions. And when you hear about other people being disinclined to get involved in violent events, coming to the defense of others, engaging in something like a citizen's arrest, well, when you see these kinds of prosecutions and legal outcomes, it's not hard to understand why people would be disincentivized. And that's going to lead to more violent crime, right? Criminals know not only do they not need, certainly they don't need fear of public that's terrorized against interfering with their violent criminal conduct. Even the police are disinclined to interfere with criminals' violent criminal conduct. Well, when you incentivize things or fail to disincentivize them, you get more of that thing. So in terms of violent crime in America, we ain't seen nothing yet, folks. Now, you all know that one of our catchphrases in law of self-defense is, if you carry a gun so you're hard to kill, man, carrying a gun's not for everybody. And if it's not for you, I wouldn't encourage you to do it. But if you've been thinking about it, maybe think about it some more. If you've been thinking about getting that concealed carry permit, maybe think about it some more. Not necessarily do it. That's up to you. All our lives are different. We have our own circumstances. And a gun is very rarely the solution to a problem. I've carried a gun my entire adult life. I've never come close to needing to use it. But when it is the solution, It's generally the only solution that will work. So something to think about. Also, of course, if you're going to carry guns so you're hard to kill, then you also owe it to yourself, to your family, to make sure you know the law so you're hard to convict. And that doesn't mean by legal tricks. We don't teach legal tricks here. It's by knowing the actual law that governs use of force. So you're so far within those legal boundaries that you're unlikely to get charged or prosecuted in the first place. And if you are charged and prosecuted, you're unlikely to be convicted if you have a reasonably sound legal defense. And with that, let's dive in now to these questions. I think I have, good heavens, I might have 300 questions here, folks. Now, hopefully some of them are duplicative, in which case I can skip them, or some will be irrelevant for other reasons. That's certainly my hope. We'll have to see about that. I'll have to check them off as I answer them. And again, often I'll be answering them in the context. This is really intended for the students from last Saturday's class. So if you weren't in that class, some of my answers may not be fully in context. But again, that's why we're offering this bundle, the Rittenhouse bundle, today only. Our 4 best-selling classes, including our advanced class, online streamed, that covers the same content we covered this past Saturday, of course, in a recorded format. And you can get this bundle, save yourself $300, but it's available today only, folks, at lawselfdefense.com/bundle. All right, so let's dive in. And again, if you'd like to post questions during this live stream, feel free to do that. I'll be going through the super chats near the end and answering as many of those questions as we can. So there's a question here from Russell. Would it have been better with regard to Kyle Rittenhouse if during his cross-examination, of course, Kyle testified on his own behalf at trial, if Kyle had said that he did not know what weapons the attackers had on their person when he was defending himself against them? This really touches upon the notion that everything you do in self-defense, your perceptions, your decisions, your actions, has to be reasonable conduct. Reasonableness is one of the 5 elements of self-defense, of course, as we talked about last Saturday. But reasonableness is based on the application of your powers of reason to actual evidence. So you can't merely imagine or speculate that that other guy whom you're defending yourself against, for all I know, he could have had a gun or he could have had a knife. That's speculation, and that has zero weight and zero value in any kind of criminal defense. Now, what you need is evidence from which you can infer that they had a knife, a gun, whatever weapon you think they might have had. And you don't need to be right about that. You're allowed to make mistakes in self-defense. Your inference can be incorrect. We're not required to make perfect decisions in self-defense. We're required to make reasonable decisions in self-defense, but it has to be a reasonable inference from actual evidence. So if someone tells you they have a gun, well, that's, even if they don't, that's evidence from which an inference can be made that they have a gun. Or they make a threatening remark and then reach for their waistband as if they were reaching for a weapon. That might be enough to make a reasonable inference that they have a weapon. What you can't do is simply imagine that they might have in the absence of evidence from which you can make a reasonable inference. So if Kyle were to be in the witness stand saying, well, I didn't know what kind of weapon they could have, well, not knowledge is not evidence, certainly. You're not responding in self-defense to a particular threat if you don't know the threat exists, and you can't speculate the threat exists. So no, I don't think it would have been helpful for Kyle to say, I had no idea what weapons they had. He needs to be responding to an actually occurring or imminently about to occur threat that he can articulate, that he was specifically aware of. And of course he was in every instance. So this is not really an issue in his particular case on his facts. But that's what you need in order to have a reasoned fear of the particular threat against which you're defending yourself against. Jason asks, the claimant of self-defense needs to produce evidence? Not totally clear there. So this has to do with the burdens of proof. There's 2 burdens of proof in a criminal trial, really in a civil trial too, but I focus on the criminal aspect of things. And mostly what we think of as the burden of proof is what the prosecution has to do in a criminal case, which is prove guilt beyond a reasonable doubt. And in a self-defense case, the prosecution has to disprove self-defense beyond a reasonable doubt. But a core function of a court is to act as a gatekeeper on the evidence and the legal arguments that are allowed to be made in court. You're not just allowed to show any evidence to a jury or make any legal argument to a jury. The court has to approve it. And we've all seen cases where the court excludes evidence, right? Because the warrant was bad or it's prejudicial or whatever. There's lots of reasons a court might exclude evidence, in which case the jury never sees that evidence. Well, the same is true of legal arguments. The court has to approve the legal argument you want to make. You don't get to make just any legal argument you want. Your legal argument, for example, has to have an evidentiary foundation. There has to be some rational basis for it. And that's true of self-defense as well. So you don't have some absolute right to argue self-defense in court. There has to be some evidentiary foundation, those 5 elements of self-defense to support that legal argument. And the burden of producing that initial evidence, what we call the burden of production, is on the defendant. Now, that doesn't necessarily mean the defendant literally needs to produce evidence, because often the evidence of self-defense is from witness statements or surveillance cameras or the prosecution's own case. So often the defense doesn't need to produce anything. There's already evidence to support self-defense in the record, in which case that's fine. The evidence exists. There's an evidentiary foundation for self-defense. You can argue self-defense. But if the evidence does not exist elsewhere, then the defense better be prepared to produce evidence in support of those elements of self-defense, or they won't be allowed to argue self-defense at trial, or may not be allowed to argue self-defense at trial. And that's bad, because inherent to any self-defense case is, self-defense is a defense of, we call it a defense of admission and excuse, because inherent to claiming self-defense is your concession that you committed the underlying act. You're not saying it wasn't me, I didn't do it. You're saying the opposite of that. You're saying it was me, I did do it. I shot that guy, but I had the legal justification of self-defense. Well, if your claim of self-defense fails, or you don't meet your burden of production on it in the first place, so the jury never hears self-defense, well, all that's left of that statement is, I shot that guy. And that, in effect, is a confession. I mean, if you deny you shot that guy, you can't simultaneously say, and I shot him in self-defense, right? That would be incoherent, illogical. Now, there are some courts that will allow you to make contradictory legal arguments. And so in theory, a judge might say, well, I'll allow you to argue self-defense, and it wasn't you. You have an alibi. But even if a court allows you to do that, you can't sell that to a jury. If you shot someone, the jury wants to know why that had to happen. And if you're telling them contrary explanations, they're just not going to buy it. I mean, you wouldn't, right? Lee asks, what % of grand juries return no indictment in self-defense cases? Folks, we don't have any statistics like that. So we don't really have anything in official accessible records on self-defense cases, or really any other criminal cases, until those cases get to the appellate record. So when lawyers talk about case law, and we talk about Lexis and Westlaw and these professional databases, legal databases that capture that case law, that make it searchable for us, those are all appellate court decisions. And they don't capture really at all what's happening at the trial level. And of course, most of the decision-making action is actually at the trial level. But unless you're personally involved in the trial, or you're following it in the news, or I guess streamed on the internet these days, unless you have personal knowledge of what's happening at the trial level, there's no easy way to research that for any one trial, much less generally across all trials, or for that matter, all grand juries. So there's lots of decisions made at the trial level that really aren't captured anywhere. And we don't capture it because nobody cares. Because what happens at the trial level, of course, is very important for that defendant, but it's not authoritative over other courts. It doesn't have precedential value. It doesn't bind what other courts can. It doesn't bind what that court might do the next day. So because it doesn't have precedential value on another court, nobody bothers capturing that level of information. So we just don't know how many self-defense cases result in acquittals or convictions or mistrials. We just don't have that kind of data. So an experienced attorney might speak to it anecdotally. I mean, for example, I can tell you anecdotally that the vast majority of self-defense claims at trial are nonsense, are BS. They're bad guy cases of self-defense. And the number of good guy cases of self-defense is almost infinitesimal. They're so rare, in part because they're so hard to win. I mean, again, a prosecution has to disprove self-defense beyond a reasonable doubt. If there's no political motive to bring a case against a good guy case of self-defense, they're generally not brought because they're so hard to win. We do see them brought in politically motivated cases, of course, because there's a different incentive there than a conviction. There's political capital, there's media coverage, there's fighting the good fight if you're on that part of the political spectrum. But generally, good guy cases of self-defense are rarely brought to trial, which is why we say be hard to convict by knowing the law. If you know the law and stay well within the legal boundaries, you're really genuinely hard to convict, and that makes you an unattractive target for a prosecution. Let's see, next one. Is the burden of production, this is from Peter, is the burden of production why we have heard in self-defense cases some lawyers insisting the defendant needs to testify? Since both objective and subjective reasonableness are needed, the only production of subjective would be the defendant's statement itself. That's a question. Well, no, not quite, Peter. So the burden of production happens pre-trial, really. A lot of stuff happens pre-trial, by the way, folks. When we watch a trial, it's like when you watch a football game, right? It's not like all those people just dropped out of space and found themselves on a football field and are playing football for the first time. They've spent their entire lives preparing for that game. Well, when we watch a trial, there's been a ton of action that happened before the trial, before the jury was selected. Although, of course, the jury selection is technically pre-trial as well. But decisions about what evidence will be permitted, what legal arguments will be permitted, what experts will be permitted or not permitted, and all of those, almost all those arguments are made and decided by the trial judge pre-trial. So in that pre-trial space, when you hear things like a preliminary hearing, it may sound unimportant, right? It's preliminary. How important can something that's preliminary be? But they're actually defining the legal battlefield of the trial in those preliminary hearings. And how that battlefield is defined can make or break the case all by itself. We've seen that in cases like Kim Potter and the Ahmaud Arbery case, where legal matters, like what's the actual definition of citizen's arrest, or what's the actual definition of reckless manslaughter, were not decided pre-trial as they should have been. They were not even decided during the trial when the jury was instructed at the end of the trial. It was still ambiguous or falsely presented. Misstatements of law were made. You don't want that. What you want is the law to be concretely defined before the jury's even selected, because in selecting jurors, or we don't really do jury selection as lawyers, by the way. We have a modest ability to deselect individual jurors, but when going through that process, that voir dire process, how you question the jury is partly a function of what the law is, how the law is defined for that particular case. And if the law is still amorphous at that point, well, it makes jury selection rather much more challenging. And of course, if the law is still ambiguous when it goes to the jury before deliberations, well, that's a failure of the trial judge. The role of the trial judge is to define the law. The role of the jury is to find the facts. But the jury should not be interpreting the law, deciding what the law actually means, how the law is supposed to be applied to the facts. They're supposed to decide the facts and then look at the law as it's defined concretely by the judge. If there's an ambiguity in the law, the judge is supposed to resolve that ambiguity before it goes to the jury, ideally before the jury selected. And when judges don't do that, it's a fundamental failure of their basic responsibility. We saw in the Rittenhouse case too, right? With the gun charge that Rittenhouse was facing. Now, thankfully, the judge ultimately resolved that legal issue before it went to the jury. And in fact, the jury never got that instruction because the charge was dismissed. But it was on the table for the whole trial. And there was no reason for that legal decision to not be made pre-trial. Nothing had changed in the law. Nothing had changed in the facts of this case. If that gun charge against Rittenhouse was illegitimate the moment before the jury was instructed, well, it was equally illegitimate a week before or a month before the trial itself. So it's one of the risks, folks. When I talk about things like there's never a 0% risk of getting convicted, there's always at least a 10% chance of getting convicted if we put you in front of a jury. And I say that's just the noise in the system. Innocent people get convicted. Well, these things, these types of things, the failure of judges to make decisions, or political motivations of jurors, or these are factors that drive that 10%. What if let's see. Sorry, I got to wind up a little bit. Oh, so back to Peter's question. So when we talk about the burden of production, that's happening pre-trial. So there's these required elements of self-defense, up to 5 of them. If any of them has zero evidence to support it, then strictly speaking, from a technical perspective, it can't have been self-defense because a required element is just missing. There's zero evidence to support it. So if the prosecution believes he sees zero evidence on a required element, he may well argue to the judge pre-trial that the defense should not be allowed to raise the legal defense of self-defense from a strictly technical perspective. And then the defense can be required to produce evidence on that particular element. Now, the good news is you don't need a lot of evidence. You basically need more than zero evidence. And that could be a statement by the defendant. But this is all happening pre-trial. So this is not why the burden of production isn't. So sometimes what'll happen is, strictly speaking, you won't have met your burden of production pre-trial, but a judge will allow you to argue self-defense anyway, in the expectation that in the course of the trial, you'll introduce evidence on each of those elements. You'll meet your burden of production as the trial proceeds. So he's kind of giving you a break. He can make you do that pre-trial, but he may allow you to make the effort during the trial. And then if you don't meet your burden of production by the end, well, then the jury may not be instructed on self-defense as part of their jury instructions, but he'll give you the course of the trial to try to produce that evidence to meet that burden of production. So in that case, if it's looking like you're not going to have evidence on one of the required elements, yeah, the defendant may be obliged to take the stand, because the evidence could come from him on any of those elements, right? He was there, right? He was the user of force. So that may be one reason why a defense is obliged to put a defendant on the witness stand. But another reason is a lot of the criminal defense attorneys simply believe that if you're going to sell self-defense to a jury, the jury has to hear from you. You killed someone. The jury wants to know why that had to happen, and they want to hear it from you. So that's not always the case. And of course, trials are complex, dynamic events. George Zimmerman never took the witness stand, but in his particular case, the state actually introduced so much video of him talking about the case, because he did recorded walkthroughs with law enforcement afterwards through the scene, that essentially Zimmerman got to testify without having to take the witness stand. I mean, it was a really odd case. So those are two reasons a criminal defense attorney may feel obliged to put their client on the stand. One, to make sure they meet that burden of production, so the jury will get instructed on self-defense. And two, if they believe that a jury simply won't accept self-defense unless they hear it from the defendant themselves. Let's see. Can I talk about jury nullification? Well, it is a thing and it's not a thing. I mean, if you ask a trial judge, he'll tell you that there is no such thing as jury nullification. The jury does not have that authority. They're obliged to follow the law as he instructs them, whether they like the law or not. On the other hand, no one knows how a jury arrives at a verdict. They're not required to explain themselves to anybody. And if they simply decide to acquit, there's nothing the trial judge can do about it. There's nothing the prosecution can do about it. So from a technical perspective, do they have the authority to engage in jury nullification? Arguably, no. From a practical perspective, can they do it and nothing can stop them? Yeah, of course. So it's, courts don't like it. If you're there in the jury room with other prospective jurors and you're talking about jury nullification, the trial judge is not going to like it. But if you just decide to do it, there's nothing anybody can do to stop you. Let's see. Is there a specific distance a person must move? What if the person is in a room? So it looks like what this question is really asking is on the duty of retreat. So how far do you have to retreat? What if retreat is complicated? What if you're in a room? What if you're on your back getting your face beat in like George Zimmerman was? Now, first of all, there's only 11 states currently that impose a legal duty to retreat before you can act in self-defense and otherwise lawful self-defense. And in 39 states, retreat's not a legal duty in otherwise lawful self-defense. Now, you can reacquire a legal duty to retreat. Things can get a little complicated, but if your claim of self-defense is otherwise sound, in 39 states, they're stand your ground states, whether by statute or by case law. There's no legal duty to retreat. generally speaking, in an otherwise lawful case of self-defense. But there are 11 states that say, hey, if you have a safe avenue of retreat and you don't take it, you lose self-defense. But that's the key. It has to be a safe avenue of retreat, really an absolutely safe avenue of retreat. You're not required to increase your jeopardy in an effort to retreat. And retreat has to be practically possible. If it's literally impossible, if you're handcuffed to a radiator, you can't retreat. And you don't have a legal duty to do anything that's literally impossible for you to do. So now, whether as a factual matter it was impossible or was unsafe, that's a factual argument that might be presented to the jury, with the prosecution arguing you had a safe avenue of retreat and the defense arguing that you did not. So that would be a factual question that would have to be resolved by the jury. But those are the legal boundaries around that question. And the jury will be instructed by the judge to look at the totality of the circumstances, which would include things like, were you trapped in a room and the bad guy was between you and the only exit? Are you somehow handicapped? So you have artificial knees, or you walk with a cane, or you're older, you can't run like you used to when you were 20 years old. Well, that would mean that what might be a safe avenue of retreat for a 20-year-old athlete is not a safe avenue of retreat for you. Or are you with an elderly parent or a young child? You're not required to abandon them. So maybe you could retreat safely, but it would mean leaving them behind to the mercies of the aggressor. You wouldn't be required to do that. So these are all factors. And if you're simply unable to retreat, like George Zimmerman, first of all, he would have had no legal duty to retreat. But even if he were in a jurisdiction that imposed a legal duty to retreat, like Massachusetts or New Jersey or New York, retreat was impossible. It was off the table because he was pinned to the ground getting beaten. So because it was impossible, he would have had no legal duty to retreat, regardless of what jurisdiction he was in. What constitutes provocation? This is from Vincent, and he uses some bad language here, I guess, to suggest that someone called you those bad words. Well, we need to differentiate what we call, how we use the word provocation in colloquial, normal, conversational English, and what provocation means under the law. So usually, mere words cannot justify a defensive response. They have to be accompanied by some kind of action. But if you provoke with intent, if you provoke someone else with the intent, so that you're provoking a physical response from them with the intent of then having an excuse to use force against them, it's the intent that matters. It's not specifically the words you might use. And the intent, like all intent, will be inferred from the circumstances, from circumstantial evidence. And by the way, folks, circumstantial evidence is just as good, if not better, than direct evidence, like eyewitness evidence. So and provocation with intent loses you self-defense. In some states, you can still regain self-defense if you withdraw from the fight. That was the case for Rittenhouse. But in many states, if you provoke with intent, there is no possibility of regaining innocence, even by withdrawal. You've just owned that fight and the consequences of it, period. So please don't do that. Let's see. David asks, could gun stickers on trucks or cars be misconstrued as provoking? Well, not provoking in the sense that I just talked about, provocation with intent. That it's hard to see how a sticker would do that. It's usually more affirmative action. Go ahead, throw the first punch, I dare you, that kind of thing. Or the dumpster guys, right? What was it they said? I doubt it. Take your swing. Take your swing. Arguably, that's provocation with intent. He's not saying take your swing because he wants to get punched in the face. He's saying take your swing so then I'll have an excuse to use force against you. But the trouble with, and when we say gun stickers, I presume we're meaning things like, what would concern me about stickers and signs and engravings on guns are things that go to state of mind, particularly an unlawful, arguably malicious state of mind. Now, we all know in the gun community, these stickers are meant as jokes, right? Keep honking, I'm reloading, driver only carries $20 worth of ammo, terrorist hunting license stickers, we don't call 911, all that kind of stuff. But the question is not how we look at it or how the gun community looks at it. The question is how those things can be presented by a prosecutor to a jury, and they can be presented as relevant to your state of mind. You don't call 911. You take the law in your own hands. You have a Punisher backplate on the back of your Glock. Why? It didn't come from Glock like that. You added that. What are you trying to say? that you're a vigilante who uses force outside the legal boundaries. That's what the Punisher does. So I would strongly discourage you from displaying things that a prosecutor can use to suggest that you have a state of mind that was malicious or unlawful outside the legal boundaries. Those terrorist hunting licenses. What do you think the prosecutor is going to say if, heaven forbid, you have to defend yourself against someone who comes from a society that breeds a lot of terrorists? It's not going to be good, folks. It's going to look like you had some motive other than pure self-defense for using force against that purpose. So, and you gain nothing from those things. You're not more likely to win the physical fight because you have that sticker or that Punisher backplate. So just, what can I say? Please don't do those things. Certainly don't put them on your car. I wouldn't even have them in my home because, something could go down in your home. Let's see. Robert asks, is someone who has martial arts, I guess, expertise, are they held to a higher standard of self-defense or withdrawal from potential conflicts in consideration of proportionality? So you are judged in part based on your capabilities and disabilities. So we talked about the legal duty to retreat. Well, you may have disabilities that keep you from retreating with any kind of speed. And therefore, what might otherwise have been a safe avenue of retreat, you would have been legally duty-bound to take advantage of before acting in self-defense, was not a safe avenue of retreat for you because of your disabilities. Perfectly reasonable argument. In fact, it goes to the element of reasonableness, objective reasonableness. Well, the same can apply in the reverse. If you have exceptional abilities, that can certainly be taken into account. So if someone is throwing for example, during the George Zimmerman trial, George Zimmerman, in the months before he was attacked by Trayvon Martin, had joined a gym, an MMA gym, to get in shape, to lose some weight. In fact, he'd lost quite a bit of weight at the time that he was targeted by Trayvon Martin. And the prosecution tried to argue that, there was no reason for Zimmerman to shoot Trayvon Martin because he could simply have used his hands to defend himself. He was an MMA expert. After all, he went to this MMA gym. And so the state actually brought in the gym owner, and the gym owner testified in the witness stand that, in fact, Zimmerman, no offense, George, but in fact, Zimmerman's fighting expertise in the months or weeks he was at that gym went from about a 1 out of 10 to a 1.5 out of 10. In other words, Zimmerman had no particular expertise in MMA, in fighting bare hands. But if Zimmerman had been an award-winning or a match-winning MMA fighter, that was an argument the prosecution was allowed to make, despite Zimmerman's apparent lack of skill. So it didn't have any traction because of that lack of skill. But if the facts had been different, if Zimmerman actually had demonstrable expertise, a high level of fighting ability through MMA, definitely that would be relevant. Because then what might have been reasonable for someone like the actual George Zimmerman might not have been reasonable for someone, the imaginary version of Zimmerman that had a high level of MMA expertise. It's not that you're being held to a different standard, but it's what's reasonable for you might be different than what's reasonable for another person. So objective reasonableness, which is one half of that element of reasonableness, is customized for the totality of the circumstances, for your particular abilities and disabilities, for your specialized knowledge and so forth. I mean, this is all stuff we spend, a lot of time talking about in the actual class, which is a good opportunity for me to bump this up again. Folks, if you missed our last class last Saturday, we only do them generally every year or two. I think the last one before Saturday was a year and a half or 2 years prior. So the live class is over, but you can get our normal online streamed version of that content. It's 8 to 10 hours of content, plus 3 of our other best-selling courses, your state-specific supplement for whatever state you prefer, defensive property, defense against riots, looting, and arson, as a bundle. We initially launched this after the Rittenhouse acquittal as a Rittenhouse bundle. We've revived it for today only, but you can get these 4 best-selling classes, not as DVDs, but as online instant access, at a 60% discount. So these are normally $500. You can get them for $200 with this bundle. So you're saving yourself $300 today if you get those. And again, it's instant online streamed access to that course content. So if I'm talking about things like the 5 elements and the components of reasonableness or the AOJ triad, that's all stuff we cover in detail in this coursework. So if it's difficult to understand some of my answers because they lack that context, all I can do is encourage you to actually get the context. Okay, let's see what else. Mark asks, during non-deadly mutual combat, so mutual combat is when two people agree to get into a fight. So they're, legally speaking, they're both initial aggressors. And if you're an initial aggressor, you've lost the element of innocence, and therefore you've lost self-defense. But if you've lost innocence, there are ways to regain innocence. And one of those ways is if your mutual combat was merely non-deadly force. So think a traditional fist fight where there's no real threat of death or serious bodily injury. But then the other guy escalates to deadly force. So he pulls out a knife or he pulls out a gun. Well, in the eyes of the law, he's then effectively started a second fight, a deadly force fight, in which he is the sole initial aggressor in that deadly force fight. And you've regained a privilege of self-defense to defend yourself against his escalation to deadly force. So you'd consented as a mutual combatant to a fist fight, but not to getting stabbed or getting shot. And what Mark asks here is, well, what if that person escalates to a chokehold? Well, the question then is what he's doing, whatever he's doing, now we're presuming that a bare fist being thrown in this context is not likely to cause death or serious bodily injury. I know there's argument about that, but for purposes of this discussion, let's pretend the fist fight was merely non-deadly force. Well, if he escalates to deadly force, whether that's a gun or a knife or a bat or a brick or a sidewalk or a chokehold, any force likely to cause death or serious bodily injury, and loss of consciousness is serious bodily injury, then arguably he's escalated that non-deadly fight to deadly force fight. He's a deadly force initial aggressor, and you've regained a privilege to use deadly defensive force to defend yourself against his deadly force attack. Now, this can apply in reverse too. If you apply a chokehold to someone, are you engaged in deadly force against which they can respond with their own deadly force defense? And the answer is arguably yes. Now, in the context of what certain types of force can be either characterized as non-deadly or deadly, depending on the context of their use. So, for example, we all think of pepper spray as non-deadly force. And in a defensive context, it is non-deadly. It's force not likely to lead to death or serious bodily injury. But I would argue, and the federal courts argue, federal prosecutors argue, certainly in bank robbery cases, that when pepper spray is used not in a defensive way, but in an offensive way, as part of criminal conduct, that the disability caused by the pepper spray constitutes grave bodily injury and therefore deadly force. So when OC spray is used defensively, it's non-deadly force. When it's used offensively, it's arguably deadly force. And the reason for that should be obvious, but when it's used defensively, you're neutralizing the threat, and then you're no longer inflicting force or harm on that threat. If it's used offensively, it's presumably being used to facilitate further harm or offense to the target, right? To facilitate a robbery or to enable you to, if you pepper sprayed a cop, to take his gun, whatever the case may be. Now, the same applies to a chokehold. So if you're attacked by somebody and you know BJJ and you can apply a chokehold to submit that aggressor, you might argue, yes, that induced unconsciousness, but it was much the same as using pepper spray. I didn't intend that person any further harm once they had been neutralized as a threat. And I think that's a reasonable argument. Don't mess it up, though. Don't accidentally cause serious bodily injury, because then it doesn't look like a mere submission hold anymore. And it's pretty easy to cause serious bodily injury to somebody if your point of attack is their neck, right? So be careful. On the other hand, if you were attacked by someone and they put you in a chokehold, I would say that's like an offensive use of pepper spray. Why are they doing that? So they can facilitate their ability to cause you further harm. Well, if you're a mutual combatant, you're an initial aggressor, just like the other guy. You both are initial aggressors, and therefore your use of a chokehold arguably is offensive and not defensive. And would be characterized that way, as an unlawful infliction of force likely to cause death or serious bodily injury, unconsciousness, and so it would be characterized differently. Let's see. So in terms of kind of a mutual combat situation where the other person, this is I'm kind of answering a question posed by Nathaniel, but I need to paraphrase it. In terms of a mutual combat situation where the other party escalates, so now they were shoving or punching, and now they've pulled out a gun or a knife. So they've escalated to a deadly force level. Arguably, they've now started a deadly force fight. I mentioned that you've regained a privilege of self-defense. How much self-defense you've regained differs by jurisdiction. So in some states, you simply regain perfect self-defense. You can defend yourself against a deadly force attack and be acquitted. In other states, they don't give you perfect self-defense back because you were an initial non-deadly combatant. I mean, you agreed to get into a fight in the first place, and they want to hold you accountable for that decision. You weren't simply an innocent defender. And so often in those jurisdictions, what they'll do is they'll say, all right, that guy did escalate to a deadly force level. If you killed him in response, instead of convicting you of murder, we'll convict you of manslaughter. So you won't get acquitted because you were involved in that first fight. You agreed to be involved in that first fight. But at least it won't be, instead of life in prison without possibility of early release, it'll be 10 years or 20 years, probably more like 10 years with some possibility of early release. So maybe you serve 5 or 6 and then you're out. Yeah, 5 or 6 years in prison is no fun, folks. It's a life-changing experience for most normally law-abiding people, but it's a heck of a lot better than life in prison without possibility of early release. So manslaughter sucks as a conviction unless the only alternative was murder. And in this circumstance where the other parties escalated, you may find yourself at least mitigated from murder down to manslaughter. Let's see. I see. Let me see. Hold on just a second, folks. All right, sorry about that, folks. Let's jump back into the questions. A non-legal question: what pistol platforms do I prefer to carry and why? Well, I don't mind answering, but it shouldn't. It's such a personal issue. By personal, I don't mean that I'm offended at the question. I mean that the answer is naturally different for everybody. So what I carry shouldn't influence anybody else's decision. For 25 years, I carried a 1911 simply in a strong side holster. Part of that was I was living in Massachusetts, which has a 10-round magazine limit. So I figured if I'm limited, I may as well carry 9 big rounds as opposed to 10 or 11 smaller rounds. Once I moved to a free state, relatively free state, Colorado, which has a 15-round magazine limit, I switched to a SIG 320 with a 15-round magazine. Carried that for the last 4 or 5 years. And just this Christmas, my lovely wife Emily purchased me a SIG 365 XL pistol. That will be my new carry pistol. I'm just waiting on the holster before I start carrying that. Unfortunately, the holsters I prefer take some time to arrive. They're not custom, but they're semi-custom, and I know I'll be asked about it. So I get my holsters from Keepers Concealment. That's Spencer Keepers. He specializes in abdominal in the waistband holsters. I think his holsters are fantastic. They're so comfortable to wear, even with a full-size pistol. I often You almost forget you have the gun on you. They're exceptionally better than other options I've tried in that appendix in the waistband position. I will say that they're ugly, they're a little expensive, and they take a while to get. And all that is worth it. So when I carry, and I carry every day, my gun is in a Spencer Keeper's concealment holster. I don't get anything for plugging Spencer. I just think he does great work. Let's see. Richard says, I bought 35 copies of your book and offered them at no charge to every member of our police department. Well, that is very kind of you, Richard. I really appreciate it. Someone here asks, I'm in a wheelchair, cannot defend myself against non-deadly force. Can I legally use deadly force to defend myself if someone unarmed comes charging at me or tries to engage in a fight? So again, what's reasonable for you is in part a function of whatever disabilities you may have. Now, you can use deadly force to defend against a deadly force threat, or in some states against a forcible felony, which really just bakes deadly force threat into the definition. What's deadly force for someone in a wheelchair against someone in a wheelchair may be different than what's deadly force against someone not in a wheelchair. So that's the legal argument you would make. Normally a punch is deemed to be non-deadly force unless there's some aggravating factor. But there can be aggravating factors. I mean, George Zimmerman was not in a wheelchair, but once he was pinned to the ground and his head was getting beaten into the sidewalk when he was mounted by Trayvon Martin and being beaten, as an eyewitness would testify at trial, ground and pound MMA style, that sustained beating became one readily likely to inflict death or serious bodily injury, a deadly force threat against which deadly defensive force was justified. So what might be a non-deadly force threat against someone not in a wheelchair could be a deadly force threat against someone in a wheelchair. But the fundamental question is the same. In those particular circumstances, were you facing a real danger, reasonable likelihood of death or serious bodily injury? If you were, then you were facing a deadly force threat, regardless of the inherent nature of the threat itself, if it would have been imposed on some other person not in a wheelchair. Serious bodily injury, the difference between non-deadly harm and deadly harm. So deadly harm means harm likely to cause death or serious bodily injury. Now, that three-word phrase, serious bodily injury, every state has a three-word phrase that means that, but often the three words are different. Serious bodily harm, great bodily harm, great bodily injury. It's like they have three wheels that they spin and some word combination comes up. But the concept is more than minor injury. Many states will define it. So it's often a broken bone, a maiming injury, something that leaves long-term damage, even if the damage is slight, or even short-term damage if the damage is substantial, like a broken bone. But it's something more than modest injury. So the general concept is the same across the 50 states. For your state-specific definition, I would encourage you to get our, the state-specific supplement course that we have for each of the 50 states. Andrew asks, laser blinding devices when used in civil unrest. What is the self-defense law with respect to encounters with attacks from lasers? So again, the question would be, is that attack likely to inflict death or serious bodily injury? And lasers come in different power levels. But if the laser being used is being targeted at the eyes and is likely to cause serious eye damage, permanent eye damage, certainly that would qualify as serious bodily injury. The trouble is not the legal analysis. The legal analysis is straightforward. The trouble is the practical demonstration of that to a fact finder, because in the nature of these things, the person who used the laser is at a distance. They're hard to identify if you can identify them at all. They'll typically abandon the laser if they're being chased. So it becomes very difficult to prove these things. As a matter of practicality, then it's really up to departments, to the governments, to decide what response they're going to allow from their law enforcement to lasers. For individuals, you put yourself in a very awkward position. I mean, if you're walking down the street and there's a riot going on and individuals in the midst of that riot are shining a laser at you, what exactly are you going to do? Are you going to start firing rounds into the crowd? That doesn't sound very practical. So I think the only real practical response is to leave the area. That's certainly what I would do. I'm not sure what other practical option you would have. You're not going to magically identify the person in the crowd who's shining a laser at you personally and shoot them. So they fall over dead. And when the cops show up, there's a dead body. There's no laser to be found. And it's just your story. You actually suffered no damage because you managed to shoot. You are allowed to defend yourself against an imminent threat. You don't have to wait to be injured. So you don't even have eye damage because you defended yourself before that happened. It's just, there's not always a perfect, satisfying answer to every one of these questions, folks. I'm sorry. The best answer is to not be there. Let's see. Someone asked, for imminence and opportunity, what if you are stopped in a vehicle and an aggressor comes to your window with a crowbar? Well, I mean, first of all, we're presuming they're an aggressor. What makes you think they're an aggressor, right? A construction worker might be walking around with a crowbar. Presumably, there are circumstances from which you're making a reasonable inference they're an aggressor. They don't look like a construction worker. There's no rational reason for them to be in possession of a crowbar in the street. There's an actual riot going on with property damage happening. The question is, if they are conducting themselves, remember in the class, we talked about imminence being defined by AOJ, ability, opportunity, jeopardy. They have the ability to cause harm. They have the crowbar. They have the opportunity to cause harm. Are they close enough to imminently bring that to bear, that crowbar to bear? And then jeopardy, are they conducting themselves in such a way that it appears to a reasonable person that they intend to bring that ability and opportunity to bear against you? If they're doing those three things, AOJ, then they're an imminent threat. That's what you would need to be able to articulate in an evidence-based way to justify that your perception of an imminent threat was a reasonable perception. In terms of being in your vehicle, many states treat an occupied vehicle much as they would your castle, your home. So you may get a legal presumption of reasonableness. Certainly, if the vehicle is breached, there's no innocent explanation for that, inconsistent with an intent to harm the occupants of the vehicle. But this is all stuff we cover in great detail in our course on defending yourself against riots, looting, and arson. And again, you can get that course as part of this bundle. It's one of these 4 courses at a fraction of the normal cost. I think that course alone is normally $100, and you can get all 4 of these courses for only $200, saving yourself $300 on the bundle. That's at lawofselfdefense.com/bundle, but it's only for today, folks. This sale ends at midnight tonight. Okay, let's see. Another car question, basically the same as the prior one. Someone asks, you recommend highlighting, taking notes in the Law of Self-Defense book? Yeah, folks, so I do recommend if you get our book, and by the way, we give it away for free. We only ask that you cover the cost of our warehouse to send it to you, which I think is like $8.95, but we eat the $25 cost of the book. You can get that at lawofselfdefense.com/free book. But I encourage people to use it as a textbook. So mark it up, highlight stuff, underline stuff, make notes in the margins, put dates in the margins, because that's all documentation of your specialized knowledge that you've acquired from the book. And if you ever want any of that knowledge admissible in court as a factor in your decision-making in self-defense, you used force under those circumstances in part because of the knowledge you acquired from the book, you need to be able to demonstrate to the court that you actually possess that knowledge at the time you use that force. And a great way to be able to demonstrate that is to have marked up the book. I'm told you can do something similar with the Kindle, but I always get nervous with digital stuff because, you know, who knows what Kindle's going to do? I mean, maybe they disappear your book and there go all your notes. If you have your own physical book, it's in your possession, it's in your control. But the question here is that enough, or should you also send your notes to yourself certified mail? So when I took Masad Ayyub's 40-hour course, he calls it MAG 40 today. When I took it back in 1996, it was called Lethal Force Institute 1. He told us, and this is 1996, pre-laptops, folks. So we took all our notes in spiral-bound notebooks. I think I filled several spiral-bound notebooks. Mas told us, hey, at the end of the class, make a photocopy of your notes, keep the photocopy in a convenient place as a readily accessible resource. take the original notes, mail them to yourself, return receipts so you sign for them when you get them back, when they arrive back. There'll be a postage mark with a date on it. Leave that envelope sealed. If you ever need to demonstrate in court that you possess that knowledge as of the date of that postage stamp, just have your lawyer open up the envelope in front of the judge, and that'll be enough. And I did that. In fact, I still have that envelope from 1996. It's still in my gun safe, unopened. I think that's overkill. I mean, do it if you like. It certainly can't hurt. But you don't need much evidence that you possess the knowledge at the time. You need more than zero evidence. Just make sure you have the more than zero evidence. Robert asks, what should you say on 911? Well, Robert, in the class, and of course you were a student in the class, but in the class, we spent 45 minutes talking about interacting with the police in the aftermath of a use of force event. And we specifically distinguish between the different forms of interaction you're likely to have with police, including the 911 call as one form, which should be dealt with in one way, interacting with the first responders who arrive in response to the 911 call, interact with them in a somewhat different way, and then the investigative authorities, the detectives, and how you should interact with them in yet a different way. But I can't spend 45 minutes redoing that portion of the class here. So if that's a topic of interest to folks, I don't know what to say, except, again, take advantage of this Rittenhouse bundle, good today only. Get these 4 courses, including that interaction with the police component of our advanced course, our what's called here the level 1 core class is the same thing. Save yourself $300 on that bundle today only at lawofselfdefense.com/bundle. Let's see. If a person has AIDS or the COVID variant and tries to bite you, is this considered deadly force since it can cause serious bodily injury? Well, certainly AIDS can and does, right? I mean, even with the medications we have today, it's you're on lifelong medication for the rest of your life, I guess, to keep the AIDS in control. I'm not a medical expert, folks, so please don't take medical advice from a small town attorney in Colorado. But that's my understanding. You'd have to know they have AIDS. So I'm not sure how you would know unless you know the person. You can't just speculate that they have AIDS. In terms of the COVID variant, it's not clear to me that the COVID variant is a serious injury to everybody. It appears to me that it's a serious injury to some people and not to others. So you would have to define for yourself whether or not you felt you would be able to convince other people, because it's not your judgment of whether or not it's serious bodily injury that controls your legal fate, right? It's the judgment of other people. It's the judgment of the police, the prosecution, the judge, the jury. Will they believe that this constitutes serious bodily injury? Well, maybe, but that's who you have to convince. So that's the argument you would have to be prepared to make. Sophia asks, are you required to display your gun before firing on a threat? Nope. Display, I mean, it would be tricky. Are you imagining firing like through a purse or through a pocket? Yeah, so display of a gun is not one of the required elements of self-defense. The required elements are innocence, imminence, proportionality, avoidance, and reasonableness. If the required elements are met, it's a lawful use of force. You're not required to shout verbal commands, to inform them you have a gun, to display your gun. None of that is required in an otherwise lawful case of self-defense. Question here, what's the difference between defensive display and brandishing, illegal brandishing? Well, it's in the eye of the beholder. One person's defensive display is another person's brandishing. And again, it's not what your actual intent was. It's what other people decide your intent was. So if they believe that you were displaying the gun for lawful purposes to lawfully defend yourself, then it gets called defensive display. If they decide that you were brandishing your gun for unlawful purposes, not consistent with lawful self-defense, then they call it brandishing. So it's in the eye of the beholder. There's no stark black and white line between defensive display and brandishing. If you show your gun, you're putting yourself at risk of brandishing, or much worse, aggravated assault with a firearm, which can be good for 20 years in some states once you add in the firearm sentencing enhancement. So just displaying your gun puts you at serious legal jeopardy that you now have to justify as self-defense. Might the authorities decide it qualifies as defensive display and doesn't carry criminal liability? Sure, but that's up to them. There's no way for you to mandate that outcome. Let's see. What kind of charge would someone who uses an O spray defensively potentially be facing? Well, again, if you're being charged, it's probably because they don't believe you were using it defensively. Or they might think you were using it defensively, but disproportionately. So if they believe that you subjectively believed you were using it defensively, but it was inappropriate under the circumstances, the degree of threat you were facing was not adequate to justify the use of OC spray, then you might be charged with a simple battery, would be the typical charge. But if they believe you use it offensively and now you're just lying and claiming you were using it defensively, or you were using it in a mutual combat, because then you're an initial aggressor, then you could well be charged with a much more serious offense. It's hard to imagine it would be a felony offense unless you did something further, but you wouldn't have much of a legal defense. If you were engaged in mutual combat, you've lost the element of innocence. You've lost self-defense as a justification. You may only be charged with simple battery, but you'll be on the hook for that simple battery. If I, as a martial artist, take any type of stance, can it provoke an attack? Again, often in these questions, right, we're assuming we're the law-abiding person. We're taking the stance for a defensive purpose. But others may not believe that. And one thing that can happen when someone takes a stance, a fighting stance, or recognizable fighting stance, is that other people are allowed then to infer from that that person has some exceptional fighting ability. And exceptional fighting ability can influence what's reasonable in terms of use of force by the other party. Someone who doesn't have exceptional fighting ability, who's being engaged by someone who does have exceptional fighting ability, well, they may be facing a barehanded threat of death or serious bodily injury because of that exceptional fighting ability that would justify them going to deadly defensive force, where they wouldn't be so entitled to go to deadly defensive force if the other person did not have an exceptional fighting ability. And again, there can be a lot of ambiguity, especially by third parties who are judging these things after the fact, who were not there, did not see what happened. A lot of ambiguity about, was it mutual combat? Who was the actual aggressor? You might be perceived by witnesses as the actual aggressor, or the other guy might have friends with him who will lie and tell the responding police that you were the actual aggressor. In which case, the other guy, when he pulled out a knife, he's going to try to justify him pulling out his knife because he made a reasonable inference that you had exceptional fighting ability because of the stance you took. That's not a reason not to learn martial arts. It's not a reason not to take a fighting stance if you believe you're being attacked. But those are some of the implications that can follow. So again, we don't tell people what to do or what not to do. Certainly, I would never discourage people from learning how to defend themselves. But we want you to be informed about possible legal consequences. The consequences don't mean you shouldn't do it necessarily, but it means that if you're doing it in an informed way, aware of what some of those downstream consequences might be. Here's a question. If you have intruders in your home, you don't know how many, where they are, and you have an opportunity to leave your home and seek help, should you stay and defend or leave? Well, that's really a tactical question. It would, from a tactical perspective, you want to do what you believe is safest for you. If it would be safest for you to leave your home, then it may be tactically prudent to leave your home. The law does not require you to leave your home. The law says that the safest place for you to be is in your home. That's why the castle doctrine exists. The castle doctrine, that properly understood, means you have no legal duty to retreat from your home if you're facing an intruder in your home. So the law won't require you to retreat, but that doesn't necessarily mean it wouldn't be prudent to retreat. I mean, if your house was on fire, you would retreat, right, from the home. You wouldn't stay there and say, I'm not retreating from this fire. I'll just fight it with our little laundry, with our kitchen sink sprayer. You do whatever is safest for you. I would imagine in most cases, hopefully you've planned ahead and you're in a position, you ought to know how to defend yourself in your home against intruders if you have the opportunity to achieve a position of safety. In my own home, I live in a very traditional 2-story home. If I hear glass breaking downstairs in the middle of the night, all our bedrooms are on the second floor. I'm not going downstairs to confront somebody down there. There's nothing on my main floor I'm willing to kill over. There's certainly nothing I'm willing to die over. I'll call the police, and those guys can ransack the first floor of my house as long as they want until the police show up, I guess. What they can't do is can't come upstairs. And I'm not leaving the second floor, so I'm up there, and those guys can do what they want until they try to come upstairs. Then I'll try to dissuade them from coming up the stairs, and if that doesn't work, things might get loud and flashy. That's not necessarily where you should draw your line, or anybody else listening to this. It's where I draw my line. Where we draw lines may be different for different people, but that's my position. I think it's legally and morally sound for me. Tina says, instead of displaying the weapon, can you verbally warn someone? So don't show your gun. Don't even pull your jacket back and show your gun, but just tell them, hey, I have a gun. I'm prepared to defend myself. You can, but remember that the crime of assault is the putting someone else in imminent fear of deadly force harm. If you tell someone you have a gun for purpose of changing their behavior, which is what you're doing in this scenario, you're putting them in imminent fear of deadly force harm. That's aggravated assault that you now have to justify as self-defense. And by the way, that would be true for you. If someone says, give me your wallet or I'll shoot you, and they have their hands in their pockets, well, they said they're going to shoot you, so that may be evidence from which you can reasonably infer they have a gun. They can be guilty of armed robbery or aggravated assault with the firearm, even if they don't actually have a gun, because what matters is they created in you a reasonable subjective belief that you were facing a deadly force threat from them. So that's what constitutes the crime. So I'm not a fan of verbally warning people that I have deadly force weapons. It's one thing to say, hey, stay back or I'll defend myself. You're not threatening them with death. If you tell them, stay back, I have a gun, you are threatening them with death. And now you may need to justify that threat as lawful self-defense, and that can be an expensive proposition. Now, again, at some point, you may feel compelled to tell them you have a gun, stay back. Just be aware of the consequences. So you may want to, not have that be your first fallback position. Let's see. Would verbal notification of having a firearm to the intruder count as brandishing? No, normally that's from Razmik. Hey, Razmik. Razmik is one of our platinum members. No, normally brandishing requires some physical conduct. You're actually physically handling the firearm in some kind of threatening way. So mere verbal notification would not be brandishing, but it does carry other potential legal negatives, as we've just discussed. John asks, an unarmed attacker who punches a person standing on concrete can easily cause grave bodily harm, concussion, or even death. Well, I mean, standing on concrete, it can happen, right? We've all seen the videos, the knockout game videos where someone's punched once, falls, strikes their head on a curb or something, suffers a serious brain injury, and dies as a result. So it can happen. But can is not really enough, because the courts see lots of fistfights, and 99.99% of the time, nobody suffers death or serious bodily injury. So the fact that in a theoretical, highly unusual circumstance, death resulted, that's not a likely risk of death or serious bodily injury. And frankly, most of the people subject to the knockout game, they never see the punch coming. That's why it's so effective. It's very hard to knock people out with a single punch if they see it coming, because they invariably flinch or move a little bit. It's quite difficult to do. Most of these knockout game attacks, they're targeting people who are simply unaware of their environments or become easy victims for a knockout punch, a sucker punch from out of sight. So, another reason to make sure that if you're out in public, you're aware of your environment, because then it gets really hard to be a victim of this kind of knockout game, knockout punch. Let's see. Lots of kind of duplicative questions here I've already answered. Someone says, can you provide an example of a non-deadly threat that could never become a deadly threat, no matter how close the person is to you? With a family history of cerebral hematomas, so that would be a brain bleed, folks. There are some people who are exceptionally vulnerable to that. If any of you taking blood thinners, for example, know that even what would be a modest injury for a healthy person can be a fatal injury for you because of the blood thinners. That all comes into that category of reasonableness and disabilities. So, what would be a non-deadly force threat for someone not on blood thinners could be a deadly force threat for you on blood thinners. So normally a punch to the face would be deemed to be a non-deadly force threat. But if you know you're on blood thinners, and of course you would know, then you know that punch to your face is in fact a deadly force threat, one readily capable of causing death or serious bodily injury. So the person standing next to you who's not on blood thinners, that same punch to him is a non-deadly force threat against which only non-deadly force, defensive force would be appropriate. That same punch to you would be a deadly force threat against which arguably deadly defensive force would be appropriate, because the threat's not the same for each of you. You're not similarly situated. And it doesn't matter that the guy throwing the punch knows that you're on blood thinners. What matters is what you know. You know it's a deadly force threat to you. Let's see. Eddie asks, is the slideshow going to be available, or do I have to continue screenshotting? Well, if you had asked me, I would have told you not to screenshot because you're copying my proprietary material. So we don't provide it as slides for a reason. But I guess I can't stop you from screenshotting it. In terms of people that take our classes, which are largely slide-based, folks, don't worry about the slides. The best thing you can do for yourself is get that free copy of our book. The book is basically a book form of the class. And it's much more concise than a slide deck, many fewer pages, given the nature of a book, and it's free. I mean, you got to cover the shipping, $8.95, but the book itself is free. Just get the book. Don't worry about the slide deck. The slide deck is the least efficient way to have this information. And of course, you can get that book at lawselfdefense.com/free book. We used to make the slide deck available, but the cost of printing it and binding it and getting it to people is so ridiculously expensive. What we have to pay other people to produce that for us, that it just wasn't worth it. We were paying like 15 or 20 bucks ourselves to get a slide deck packaged up to be able to provide to someone. And we'll give you the book for nothing. So just get the book at lawselfdefense.com/free book. Is displaying the gun in a holster or reaching for the gun without showing it? So these are all the same questions. If you make the other person aware that you have a gun for the purpose of changing their behavior, which is what all of this is, you're arguably committing aggravated assault with a deadly weapon, a felony charge, good for a decade or more in prison that you would then have to justify in self-defense. So I discourage you from doing that. I mean, often, of course, it works. Often, most civilian uses of self-defense with a firearm involve no shots fired. The mere display of the gun was enough. But you can't count on it, and you're incurring a great deal of legal liability. So I would prefer that what I do personally is carry my gun in such a way that it's extremely accessible to me very quickly, and I can be prepared to present that gun very quickly without making the other person aware that I have a gun, without first having to put my hand on the gun or show the gun, or one of the weaknesses of a strong side carry is that if you move your hand just by the grip in a strong side carry, it looks like nothing in the world but someone reaching for a gun. Again, that's not a reason not to strong side carry. I did for many, many, many years. But that's one of the downsides from a legal perspective. They now can make a reasonable inference you have a gun. I personally prefer that anyone attacking me not have any idea I have a gun until I need that gun to start making loud noises. Let's see. Do I have to tell the attacker I have a medical condition if they hit a specific area? It could kill or do me damage. Well, you don't have to. There's no requirement for doing that. You're allowed to defend yourself against the threat to you if the medical condition, like a blood thinner, creates an unusual medical condition that's real for you, that's what you're allowed to take into consideration. Doesn't matter if your attacker knows of it or not. Now, I am a fan of verbal communication to an attacker if you think it would be productive and it can be done consistent with safety. Things like stay back, sure. Using verbal commands to strip ambiguity out of a situation. If you're screaming at someone to stay back and they keep coming closer, that looks a lot like that element of jeopardy for the requirement of innocence, right? It's conduct consistent with someone being a threat. So I think verbal commands can be very helpful, but they're not required. And I certainly wouldn't do it if doing it was inconsistent with safety. And frankly, telling an attacker that you have some exceptional vulnerability to harm, is that going to dissuade them from targeting that point or encourage them to target that point if they're mad at you? I don't know. Let's see. In determining whether a potential assailant has the ability, this is part of that AOJ of eminence, to cause harm, can you consider the threat's size? Yes, of course. So ability to cause harm is based on the totality of the circumstances, which would include things like that other person being much larger than you or stronger than you or having an exceptional fighting ability that you don't have. And by the way, a lot of this is kind of baked into the cake when we're talking about a female defender and a male aggressor, right? So most of the time, the male aggressor is going to be larger, stronger, be more familiar with physical violence than will be their female victim. So a lot of these factors tend to be baked into the cake. Then, not always, of course. I don't mean to disparage the ladies out there who are large and strong and have exceptional fighting ability. I know you exist. I've met you, but you're not the norm for your gender. But yes, all of this would come into play in determining that person's ability and the degree of harm they'd likely to be able to inflict. So when I say that, normally a traditional fist fight is deemed to be non-deadly force by the courts, well, that can change. It can be a deadly force fight if you have these kinds of aggravating factors. One of the aggressor is much stronger, much larger, has an exceptional fighting ability that the defender does not have. My next door neighbor throwing a punch to my face is not the same as Mike Tyson throwing a punch to my face, right? Mike Tyson can readily cause me death or serious bodily injury with a single punch because of his exceptional fighting ability and other factors that can all be taken into consideration. But it's all taken into consideration because of actual evidence from which you're making inferences. This is different than the traditional fist fight because that guy was huge. And by the way, he doesn't have to be huge. When you think about wrestling and boxing, we MMA, those sports differentiate their competitors by body weight in intervals as little as 8 or 10 pounds. So a 20-pound difference can make a big difference in a fight. And that's something certainly I would be prepared to argue in court. Now, it's sufficiently close to being specialized knowledge. That's fighting sports distinguished competitors by as little as 8 or 10 pounds, that you may want to make sure you document that as specialized knowledge, perhaps in the law of self-defense book, to make sure you'd be able to admit that into evidence if you were ever in trial and that was a factor in your decision to use force. But certainly those are all factors that could come into play. More medical conditions, I've already covered that. Spinal conditions. Yes, all of those are either disabilities that would inhibit your ability to defend yourself or make you exceptionally vulnerable to a higher degree of injury. Those would all be relevant on the grounds that I've already discussed. Michael asks, I guess Michael must be a firearms instructor, is telling a student in a CCW class what you would do or might do in specific circumstances regarding use of deadly force not a good idea? It's not my practice to do that. As you've heard already, just in the, my God, an hour and a half we've already been together. I don't tell people what to do. I only try to inform people about the implications or consequences they might want to consider for particular choices. So it would have to be a very extreme circumstance in which I'd be willing to say, yeah, under that circumstance, I would absolutely do X or Y. What I tend to do instead is describe to people, well, these are the factors I would consider in arriving at a decision. Could I retreat? Could I use a lesser degree of force? Things along those lines. But the ultimate decision is made by the individual, and they bear the consequences. So making absolute statements, I mean, these situations are so complex and dynamic that it's very difficult to make absolute statements. Um, but what you can do is make, absolute statements about the factors, how to ask the question. That's what we try to teach people at Law of Self-Defense. That's what I would try to encourage instructors to teach their students. Less, here's the absolute answer, and more, this is how you ask the question. And then, make sure you have the knowledge to have an informed answer that fits for you. Different people will have different informed answers, and some of them are riskier than others, but different people have different risk profiles. So not everyone has the same absolute answer to the question. The risk is never zero. So the only way for the risk to be zero in a fight is to not be there, not be in the fight. But the moment you're engaged in that physical confrontation, there's a greater than zero risk that you're going to die in that fight, and a greater than zero risk that you're going to spend much of the rest of your life in a cage. So you train to fight, you arm yourself in self-defense so that you reduce the risk of losing the fight to as close to zero as possible, but it's never zero. And you learn content like this. You take law of self-defense courses, and I'll pop up our little bundle sale while I'm talking about this. You educate yourself on use of force law so that you reduce the legal risk to as close to zero as possible, but it's never zero, folks. So I just urge you always to keep in that mind. And this bundle are 4 best-selling courses. Save $300 on those at lawofselfdefense.com/bundle today only, folks. These are normally $500 for this set of courses. You can get it for $200 today. Save yourself $300 today only. Let's see. Richard asks, if you don't engage in a fist fight and you back away from the fist fight and the attacker continues to close distance with you, can you display a weapon or threaten deadly force to dissuade the attack? The trouble is, once you go to deadly force, you need to be able to articulate why deadly force would have been justified. There are jurisdictions where they might make a decision to say, well, he showed a gun, but he didn't shoot a gun, so we're not going to call that a use of deadly force. We're not going to make that person justify as if they had fired the gun. But there are other jurisdictions that will do that. I mean, in Massachusetts, mere display of a gun requires the same criteria as if you'd fired the gun into that person. You have to be able to articulate an imminent threat of deadly force harm to yourself or another innocent person. And in jurisdictions that are not that rigorous about that, well, a lot of it's a judgment call being made by that cop or that prosecutor or that judge or those jurors, and you can't be certain what they're going to decide. They may hold you to that standard. So I'm very disinclined to go to deadly force in the absence of an apparent deadly force threat. That said, that doesn't mean you have to do nothing. I mean, I encourage everyone who carries a gun for personal protection to have a diversified self-defense toolbox. Make sure you have non-deadly means of defending yourself too. So if that person keeps closing proximity, they're not apparently presenting as a deadly force threat, so you're not comfortable going to your gun. Well, you can be comfortable going to your OC spray because that's non-deadly force. That's proportional to even a non-deadly force threat. But that only works if you have the pepper spray and know how to use it effectively. Or if not pepper spray, something else. Barehanded fighting techniques, a taser, a baton. I'm not a fan of batons and tasers for civilian self-defense, but in theory, those could also be applicable as when used appropriately as non-deadly force that's proportional to a non-deadly force threat. If all you have is the gun, a lot of the cases I consult on are law-abiding people, never been in trouble before a day in their lives with the law, and they got scared by a threat, and the only tool they had was their gun, their concealed carry permit, and they went to the gun because they were scared. And the authorities decided, well, at worst, you were facing a non-deadly force threat, so your going to the gun was disproportional, unlawful. You lose proportionality, you lose the justification of self-defense, and they end up charged with aggravated assault with a firearm, and they're looking at 10 or 20 years in prison. And then they end up spending a lot of money to try not to go to prison. Most of those cases, almost all of them that we consult on, we manage to get those charges dismissed, or at least we get the person put into a diversion program where if they keep their nose clean for a certain period of time, the charges are dismissed. But it costs that person a lot of money. Their lead counsel is typically getting $10,000 to $30,000 as a pre-trial retainer. My minimum for a law self-defense consult is $10,000, and effective this year, by the way, we're not doing consults for anybody who's not a Platinum Protection member, not a member of our Platinum Protection program. So it's not available at any cost if you're not a Platinum member. But traditionally, it was another $10,000. So they're looking at a lot of money, and we get the charges dismissed. That's a huge win. They don't have to go to trial. They don't have to face that greater than zero risk of getting convicted and sentenced to 10 or 20 years in prison. So that's a huge win, but it's a pretty expensive darn process. And you don't know the charges are going to get dismissed until they get dismissed. So the whole time you're thinking, oh my God, I could still go to trial. And then it's more money on top of what you've already paid. And again, the chance of conviction is never zero. Modifications to firearms. Yeah. So again, I already spoke about stuff that goes to state of mind, Punisher logos, watch for flash engraved on the muzzle crown, kill them all, let God sort them out, put on the gun. Don't do those things, folks. Don't put anything on your gun that goes to state of mind. And as I'm also uncomfortable with mechanical modifications that affect how the gun fires, by which I really mean substantive changes to trigger. I don't mean like smoothing of a trigger. Nobody really cares about that, but changing a 5.5 pound trigger to a 3.5 pound trigger, like with a drop-in trigger kit, makes me very nervous. Or disabling any safeties, intentionally or inadvertently. Folks, there are some very high quality, for example, Glock aftermarket triggers out there, and there's garbage out there. There are aftermarket triggers you put in your Glock, and some of those internal safeties in the Glock don't work anymore. So you disabled safeties unintentionally, but you've still done it. And then other people, they decide they don't like a thumb safety, or they don't like a grip safety, or a magazine safety, or whatever, and they disable it in their gun. Folks, you're never going to convince anyone that you knew better than the engineers who designed that gun what safeties it needed. And by the way, when you disable safeties, you are increasing a risk of an unintentional discharge. And now that you've disengaged the safety, that's not just negligence. That's reckless manslaughter, because you, by disabling the safety, you consciously created a risk that the gun would fire when it wouldn't have fired had the safety been in effect, and you disregarded that risk. And then if you shoot someone and kill them, that's reckless manslaughter every day. And we have so many great self-defense guns to pick from. Just pick one that doesn't have the safeties you don't like. Easy enough. But don't be messing with safeties on your gun or substantive changes to the trigger. Other stuff, cosmetic stuff on the gun, stippling, different sights. I mean, on a Glock, you have to change the sights. They give them to you with those garbage plastic sights on it. So at the very least, please put some good metal sights on the gun, or putting a dot on the gun. Deburring a gun, cosmetic stuff I couldn't care less about, because it doesn't affect how the gun fires, and it doesn't go to state of mind. Let's see. Vincent asks, so the highly trained martial artist is hogtied no matter what they do? No, the highly trained martial artist is held to the standard of a highly trained martial artist. That if he has that exceptional fighting ability, he has skills that the normal person doesn't have, and he's expected to conduct himself consistent with those skills. That's it. That's not a reason not to get trained in martial arts, but you're going to be held to what you're actually capable of, in the same way that you would only be held to what you were capable of if you had some disability. Yeah. Mark asks, so he asks about batons, ASP baton or collapsible baton versus OC spray. My hesitation about batons is not that they can't be extremely effective non-deadly force weapons. They can be. In skilled hands, they are shockingly effective non-deadly force weapons. My concern with batons is that in the blink of an eye, their use can shift from non-deadly to deadly, or appear to shift, or accidentally shift. So if you have an ASP baton and you're striking somebody below the waist, right, in the legs, the knee, man, that can be really debilitating to that aggressor, but arguably not causing death or serious bodily injury, arguably only non-deadly force. Most police who carry batons today are trained to use batons in that way. They're hitting the big muscle groups in the leg, for example, in the thigh. But that same strike to the head is clearly deadly force, clearly readily capable of causing death or serious bodily injury. So what happens if you're striking at someone in the thigh and they suddenly bend over and you accidentally strike them in the head? Well, an accident shouldn't carry legal liability, but is that how it's going to be perceived by others, by a prosecutor, by a jury? Or is it going to look like, hey, you were not using this ASP only as non-deadly force, you were using it as deadly force? Also, of course, other people don't know how you're intending to use that ASP. And they're going to know that if you're striking people in the head with it or intending to strike people in the head with it, you're intending to use deadly force. So have you now escalated a non-deadly force fight to a deadly force fight? It's an argument that could be made. In contrast, OC spray, it's pretty difficult, at least in an otherwise healthy person that you're spraying, to in the blink of an eye unintentionally or apparently be making use of deadly force, as can be the case with a baton. So that's my reluctance with batons. Let's see. What about dogs? So someone has a vicious dog on a leash, and the dog's behaving aggressively, and the person who has the dog on the leash is going to release. They're threatening to release the dog on you. Well, then the dog's being used as a weapon, right? Is that lethal or is that not? Well, it depends on the dog, right? I mean, you have to make a reasonable inference from the evidence. If it's a Chihuahua, is it a reasonable threat of death or serious bodily injury? I guess any dog bite, any penetrating dog bite, is that serious bodily injury? I guess it could be. On the other hand, there are dogs that are unquestionably deadly force threats, right? Um, I don't even want to name breeds because I'll just get a bunch of hate mail from people who love that particular breed. But we all know that there are some dogs that get to a certain size and state of aggressiveness that they kill people. I mean, there are some breeds of dog that kill people, maim people, rip arms off of people, permanently maim and kill people. That kind of dog is clearly a deadly force threat. If the person's using it as a deadly force weapon, well, can you shoot the dog? Well, you can shoot the dog. I mean, you can defend yourself against that dog. It's not really self-defense in the way we normally use that term in a legal perspective. I mean, in a colloquial, plain English perspective, of course, you're defending yourself against the dog. But in as a legal term of art, when we say self-defense, we really mean the use of force against other people, other human beings, not the use of force against a dog. To use the force against another human being, you have to have those 5 elements of self-defense. To use force against an animal that's threatening you, you don't need to meet those 5 elements of self-defense. It wouldn't be your legal defense if you were criminally charged for using force against that animal would not be, it's not going to be assault or battery or manslaughter or murder. It's going to be unlawful harm to an animal or something like that, or perhaps reckless endangerment. If your use of a gun, for example, endangered other people in the neighborhood, very common for people who use guns against apparently aggressive dogs to be charged with reckless endangerment if their firing of that gun endangered other people in the community. Now, in theory, you can still defend yourself against that charge of reckless endangerment if you can convince the authorities that your use of force was justified. But that would really mean, because your firing in the shot was a deadly force threat to others in the community. So you better be able to compellingly argue that you were facing a deadly force threat from that dog. And they have to believe you. And again, they weren't there. They didn't see what was actually happening. And of course, the owner of the dog is going to describe the dog as the friendliest thing ever, right? So, I mean, you do what you have to do in the moment, but I would not be looking to jump at the opportunity to be shooting an aggressive dog. Now, pepper spray often works pretty good against dogs too. They have a lot of mucous membranes in the front of their face there, so that might be another option to consider. Let's see. So someone asks here about a home invasion type of scenario. They're in their bedroom. They know there's an intruder in the home. They bunker up in their bedroom. The intruder comes into the bedroom, continues to advance. They shoot them. The threat's neutralized. The cops come. Later, they find out he has no tool or deadly weapon. Am I justified shooting him? Generally speaking, there's going to be a legal presumption that a forcible and unlawful intruder in your home was reasonably perceived by you as an imminent deadly force threat, and that person, a presumption that that person intended to cause deadly force harm in your home. Defense in your home is one of the hardest situations to screw up from the defender's perspective, because it's such a hard sell to a jury. If there's a forcible, unlawful intruder in your home, the juries are going to know nothing about self-defense law other than what the judge tells them in the jury instructions. They're going to know nothing about guns or martial arts or the tool or drill or terminal ballistics or how ineffective handguns really are or the limitations of pepper spray. The jury doesn't know any of that inherently. You have to assume that they won't know any of that. But they all live in a home, and they all know what it would be like to confront a forcible, unlawful intruder in their home. And to get them to convict under those circumstances is almost impossible. Now, people do screw it up. Defenders do screw it up. If you scare that intruder out of your home and chase him down the street and shoot him, that's going to be different. If they were climbing back out the window when you shot them in the back while they were doing that, that might be different. If there's evidence that suggests they weren't a genuine intruder, that they were an invited guest or a co-dweller or a business partner you were having a financial dispute with, or there was maybe some other motive other than defense against the genuine intruder that motivated your shooting, well, yeah, then the prosecution might try to make those arguments overcome that legal presumption. But if it's a genuine, forcible, unlawful intruder in your home, it's very difficult for that self-defense narrative to go bad for you. It's possible you could screw it up. I mean, I see people do things like they'll put out bait, like maybe they've had property stolen before several times, and they decide the cops are ineffective, and so they decide, you know what, I'm going to put bait out. I'm going to put like a purse out in my opened garage, and the next time that some person comes into my garage, then I'm going to shoot them, and they get convicted because you can't create the circumstances necessary for you to use force in self-defense. That doesn't look like self-defense to anybody. But if you're a legitimate home defender facing a forcible, unlawful intruder, very difficult to screw that up. Possible to screw it up, but very difficult. Let's see. So consciousness of guilt evidence. This is being asked in the context of the Kim Potter trial. That was the police officer, the taser gal who just got convicted in the death of Dante Wright. And she had expressed a lot of remorse immediately after shooting Wright. And the question is that consciousness of guilt evidence? I would argue, so consciousness of guilt evidence is evidence that suggests the person themselves believes they're guilty of doing something wrong. And this is typically conduct like lying to the police when they arrive at the scene. I don't mean just being silent, which of course you have a right to do, but actually lying, demonstrably lying to the police. I didn't shoot that guy when it was you who shot the guy. And of course, then they discovered the truth. Someone who engaged in lawful self-defense and is prepared to justify that conduct is not going to say they didn't fire the shot. Lawful self-defense, in fact, requires that you can see that it was you that fired the shot. Or tampering with evidence or with the scene. So this whole, if you shoot someone outside your house, make sure you drag them inside the house before you call the cop. Folks, you drag a body that you punched holes in across the ground into your house, everyone's going to know what you did. Or flight from the scene for purposes other than safety. You can always flee for purposes of safety, but if you keep running, it looks like you're trying to avoid accountability for whatever it was you did. And all of those are evidence of a guilty mind, right? That's what consciousness of guilt evidence is. And a jury can be instructed that if they believe that conduct has been proven beyond a reasonable doubt, that not only does the prosecution think you're guilty, but apparently you think you're guilty. And that's a horribly destructive jury instruction for your jury to get. So you don't want to engage in consciousness of guilt evidence. But not everything is consciousness of guilt evidence. And really, even in the Potter case, the prosecution didn't really argue it was consciousness of guilt. For example, they didn't request a consciousness of guilt jury instruction to be given to the jury. What they used that remorse, that apparent, I think, genuine remorse conduct from Potter 4 was to suggest that she knew she did something wrong. I mean, one of the defects in the Potter prosecution is that the prosecution essentially convinced the jury to convict Potter of manslaughter on the grounds of negligence. Negligence is only good for civil liability. It's not a basis for criminal liability. That's how the jury was misinstructed in the law. Negligence, that she knew she had done something wrong, or should have known she had done something wrong, just this wrong thing, that's not enough for criminal liability. Criminal liability requires that you were consciously disregarding a risk in the moment. The fact that you knew afterwards you had made a mistake, of course she knew afterwards. She thought she was firing a taser. Even the state never claimed she knew she had a gun in her hand. She thought she was firing a taser and heard a bang. Well, then she knew something wrong had happened, and of course she felt terrible about it. But for criminal liability, the requirement is supposed to be that she knew she was doing something wrong in the moment, and I don't believe there's any evidence of that. So I wouldn't characterize her remorse afterwards as consciousness of guilt evidence. You just knew something had gone wrong, like accidentally backing over a child. But that's different than knowing you'd intentionally done something wrong, like you'd unlawfully shot someone, so you're dragging them into your house so that it will look more lawful. It's a different kind of conduct. Matt asks, seems like there's a fine line between defensive display and brandishing. I've already answered this question, really, so I will just say yes, absolutely. It's a very fine line, and it's up to other people's discretion and their judgment, and it may not go your way. So when you defensively display, you're running the risk that you'll be charged for brandishing or even a more serious felony level crime like aggravated assault with a firearm. Let's see. How would the 5 elements affect being a member of a party? You're a group, you're a couple on the street or a couple in the house, and one person in that group may have justifiable self-defense with deadly force, but they don't have the ability. Can you make a justification to use deadly force on their behalf? So this is from Michael. Yeah, so this would be a defense of others scenario. So generally speaking, you're permitted to use defensive force in defense of another person to the same extent they would be privileged to use force in defense of themselves, or alternatively, to the same extent you would be privileged to use defensive force if you were in their circumstances. So say you're walking down the street with your elderly dad, you're healthy, he's on blood thinners. Someone comes up and goes to punch you, arguably that's a non-deadly force attack on you. You would only be privileged to use non-deadly force in defense against that attack. Alternatively, that same person goes to punch your father because he's on blood thinner. He's exceptionally vulnerable to death or serious bodily injury, even from a mere punch. That's a deadly force attack upon him. He would be privileged, arguably, to use deadly defensive force in his own defense. Under the doctrine of defense of others, you would be privileged to use deadly defensive force on his behalf in his defense. Now, the only caveat here is that anytime you're using deadly force, it also has to be actually necessary, meaning that there was not some obvious alternative to using the force. So if you would have been capable, for example, of just shoving that person aside before they punched your father, the authorities might argue that deadly defensive force wasn't actually necessary because you had a non-deadly force option that would have effectively secured your father's safety. But that's how the legal question would be structured in that scenario. Let's see. Someone here writes, Maryland writes, California is not OC friendly. What about other alternatives? And they mention a few things. Homemade pepper spray concoctions. No, that would not be better. If California, and I don't know that California doesn't like OC. My expertise is not weapons law. It could be true, it could not be true. I just don't know. But if they don't like factory made OC, they're definitely not going to like some homemade concoction that you put together. A thermos of scalding water I just don't understand how that would be practical. You're gonna boil a thermos of water every time you go out? Or you're saying you would only do that? I mean, you're facing a threat. Now you're going to boil some water. This doesn't make any sense to me. Berna, then she asked about Berna. So Berna is a pistol-like device that fires, I believe it's OC pepper balls. I'm not a fan of the Berna system because it looks just like a gun. And it creates all kinds of legal liability. You know, if you point something at somebody and they perceive it as a gun, it doesn't matter if it's a real gun or a toy or a fake gun or an unloaded gun. That's aggravated assault with a deadly weapon if they reasonably perceive it as a gun. And that would be true for a Berna gun. So I think you're running a lot of legal risk with a pistol-shaped OC dispenser that you don't run into if you're just using a standard OC type canister display. In any case, if OC is not acceptable in that jurisdiction, Berna is not going to be acceptable either. And keep in mind, I mean, just look at what happened with Kim Potter with a taser and a pistol that were both pistol-shaped. I worry about anything that's pistol shaped that's not an actual pistol. Just like I don't encourage people to put blanks in their gun or threaten with an unloaded gun or have the first round be a blank and then later rounds be real bullets. The possibility of confusion and unintentional use of deadly force on another person is too great. How about hurling a 1 pound lead fishing weight? Well, you must do some fishing. A 1 pound lead weight that's like, what's that for? Whales? But in any case, when it comes to deadly defensive force, the law doesn't care overly much in terms of the justification for that use of force, what the precise nature of the deadly force is. If you're privileged to use deadly defensive force, you're facing an imminent deadly force threat, the law doesn't much care about the nature of your deadly defensive force. It could be a gun, it could be a knife, it could be a baton, it could be an anvil dropped from a great height. It could be a 1 pound lead fishing weight. It could be your car. It could be anything. The key question is not what's the particular mechanism by which you're inflicting that deadly defensive force. It's were the boxes checked? Were the conditions to justify the use of deadly defensive force justified? Now, on the margins, there can be complications depending on the precise nature of the deadly force used. For example, if you end up convicted, your use of force was not justified, there's often sentencing enhancements for the use of guns. If you use a projectile weapon like a gun, it's more likely or it's easier for a prosecutor to also argue reckless endangerment towards other people because bullets don't miss, right? They continue moving until they hit something. And of course, there's always, weapons law and gun law concerns. Again, I don't do gun law, but if you're in a jurisdiction where you're not supposed to have the gun, you could face independent gun charges that are completely independent of whatever your use of force justification legal arguments might be. So I'm not saying entirely the weapon doesn't matter, but in the context of use of force justification for deadly force, that use of force analysis does not much care precisely what the deadly force is. Well, okay, so I was going to jump to the next question, but I've been talking for 2 hours, folks, and believe it or not, oh man, I still have a couple hundred questions here. So here's what I'm going to do. I'm going to see what the response. Well, first of all, before we sign off, I'm going to look for any super chats. So if you put in a super chat in the comments, I will check for that before we sign off. If you're but otherwise, I'm going to stop now scrolling through this list of questions. We do have a couple hundred more to go. So if the comments look like people are interested, they like this kind of content, then I'll schedule another one of these live Q&A shows, extended format for tomorrow morning, probably the same time. And we'll do it all again if people like this kind of content. If people found it boring or were disinterested, no offense taken, but obviously that would answer the question for whether we should do this again. So let me chop to the comments and see if we have any I'm obligated to answer as super chats. And if you have feedback in the comments about whether we should do this again, feel free to share that as well. So let me scroll through. Thank you, Kenny, for your contribution. Clumsy asks, what's the biggest misconception about self-defense? Probably the single biggest conception about self-defense is that it exists in some absolute form. Like if I do X, that's lawful self-defense. I don't have any legal liability. There are no absolutes. The law is relatively straightforward, but the law is being applied to facts that are often not straightforward, that are often ambiguous. And that application of the law to facts is being done by human beings who are by definition, imperfect, sometimes biased. That's all part of that noise in the system I talk about. So the notion, a lot of people would like to believe that, hey, if I'm facing X and I do Y, I absolutely have zero legal liability, nothing to be concerned about. My risk of prosecution or civil suit is zero because I did things the right way. It's never zero. So I think the biggest misconception is that the risk can ever be zero. Stogies and Boomsticks, thank you very much for your contribution. Toby Jean writes, here's a super chat for the amount that I owe, and it's a very generous super chat, because your lovely wife let me through the gate after I ordered the wrong thing on the website. LOL. I wish there was a read this in Binger voice option, and Nick was here to add spice. Yes, it's always fun to do shows with Nick, but obviously he works like 24 hours a day already on his own content. I would welcome Nick anytime he cared to be a guest on my show. I'm not sure he would ever have the time to do that. But yes, great fun working with Nick all the time. Stogies and Boomsticks, this class and Q&A have been an unmeasurable value to me. Thank you so much. Thank you, Stogies, for a second super chat. Much appreciated. Scroll. Heather says, my husband just took the online class Saturday. He wants to take the instructor class. So for folks who don't know, we do have a law self-defense instructor program. It is all online streamed. It's not really taught live, except that all our instructor program graduates have direct access to me personally for any questions they might have. So it's personally engaging in that respect. Where our door is always open to our instructor program graduates. So what the instructor program covers in a nutshell is, of course, everything that's covered in our core class and then a lot more. So we spend a lot more time talking about the law, how the law actually works, how law is actually created, how a trial actually works from the pre-trial state, even before that, actually from the first interaction with law enforcement, all the way through the first appearance before the magistrate, bail, charging, indictment, pre-trial hearings, the various steps of a typical criminal trial itself, and then the whole appellate process of appellates. So in a great deal of detail, so you know how the machine actually works. It's like the difference between knowing how to operate a car and actually being a mechanic that could take a car apart and put it back together. We talk a lot about how to read case law, understand case law, interpret case law, how to do a brief. In fact, that's one of the requirements. It's one of the assignments is how to brief a case. In other words, that's a phrase lawyers use to say, distill the case down to its essential elements relative to self-defense law. A lot more like that. If you go to lawofselfdefense.com/instructor, you'll see the various chapters and a detailed description of how that all works. Let's see. I see a note thanking my lovely wife, Emily, for letting me come out to play with the other lawyers. Yes, I have great fun on the rare occasions I'm on Nick's late time show, but Emily is very careful to come drag me back to bed by 2 o'clock in the morning or so. And I appreciate her being willing to let me come out and play on some of those nighttime shows. But the fact is, folks, I'm typically up by 5 o'clock in the morning to start my workday, and staying up till 1 or 2 o'clock in the morning is not conducive to my normal work schedule, as much fun as it is. Taylor says, grew up in Texas Hill Country. You got to ride west from Ingram and Texas. Yes. So I'm actually planning a trip to Texas Hill Country, maybe next month, maybe late February, maybe early March. I'm hoping for late February. I have not ridden Texas Hill Country, but I have a week-long trip route planned based out of Junction, Texas. And I'm hoping I can pull it off. It all depends upon the work schedule. Let's see. Tim gave me a super chat, says, I owe you my PayPal F up, but you still sent the bug. Oh, I guess I guess he ordered the book and the payment didn't go through, and we sent him the book anyway, but he made it up here in the super chat. Thank you very much, Tim. It's very kind of you. Let's see. Thank you, Cheryl, for your super chat. Happy to answer your question about OC spray. Tim, thank you for your super chat, and thank you for your thank you. I love my work. I'm happy to do it. Frankie Two Finger says, hey, my family owns a cabin way out in the Junction, Texas Hill Country. You're welcome to use it. Let me know if you want to. Yeah, well, you can send me an email at support@lawselfdefense.com. Put forward to Andrew in the subject line, and they'll bring it to my attention. I'm planning to base my week or so in Texas Hill Country out of Junction. So I would definitely be interested in taking that under consideration for sure. Let's see. Anything's better than a Hampton Inn for a week, folks. Nathan asks in Super Chat, does adding a suppressor invalidate a firearm for CCW? Okay, so I don't do gun law. So, and a suppressor is an NFA item that has lots of legal requirements around it, both federal and state, depending on what state you're in. So I want to caution, to the extent there's gun law issues around a suppressor, I would not be the source for expertise there. In terms of use of force law, assuming that your possession of the suppressor is lawful, if we assume that, then there's no black and white problem with using it for use of force purposes. It doesn't create any black letter of the law legal problems for you, assuming you're possessing it legally in the first place. What it does do is it makes your use of force unusual, not the norm. Most people don't use suppressors. And anything that's unusual, even though technically it shouldn't matter, but like an unusual caliber or an unusual gun or a fully automatic gun, even if you don't use it on fully automatic, or a suppressor, these are things, if the question is, can a prosecutor talk about this? Can a prosecutor use this against me in court? By which what we really mean is, can a prosecutor talk about this in front of the jury in an effort to make me look bad? The answer is yes, a prosecutor can talk about anything. If you legally own a fully automatic weapon and use it to fire a single round into a bad guy, and the prosecutor decides he wants to take you to trial, I assure you he will describe that as a machine gun. I mean, they tried to describe Kyle's gun as some kind of machine gun during his trial, even though it was only semi-automatic. If you use a suppressor, to the extent that the public, the jury, might perceive a suppressor as something only mafia guys use to commit hits in the movies, can that be used against you in court? I mean, it doesn't, not using a suppressor is not an element of self-defense, so it shouldn't matter on the legal merits. But it's providing something that the prosecutor can talk about in an effort to make you look bad. And if you think they wouldn't, when Zimmerman was prosecuted, the prosecutor screamed to the jury about the fact that not only did Zimmerman have a gun loaded, he had one with a round in the chamber in the ready-to-fire condition, as if you would carry a gun any other way than with a round in the chamber when you're carrying it for personal protection purposes. It's a ridiculous argument on the merits, but is it one the prosecutor was willing to make to the jury? Yeah, and he made it. Did it get any traction? I doubt it. Apparently not, because Zimmerman got acquitted regardless. But prosecutors are willing to make those kinds of arguments. So I prefer that people's defensive tools be as boring as possible. Glock 19, boring. Doesn't mean you have to pick that gun. I don't carry a Glock 19. I have a lot of Glocks. I choose to carry, soon, my SIG 365 XL. But something as boring and unnotable as possible. The more unusual you get, I mean, strictly speaking, if there's a forcible, unlawful intruder in your home, threatening to kill you, you could neutralize that threat with a spear gun that you would use for fishing when scuba diving. And that would be lawful, but it would be really weird. And you don't want to be weird. So again, that's not telling you not to use a suppressor. I know, especially a lot of folks are interested in using a suppressor if they're planning to use a long gun, like an AR platform gun for home defense. A lot of them like to put a suppressor on it because those guns are super, super loud indoors. I get it. I'm not telling anyone not to do that. But that's the one of the legal implications you'd want to be aware of. By the way, if you are going to do that, you might want to have the option of bringing in like an expert on suppressors to talk about hearing damage and all that kind of stuff. If that's part of your decision making and mounting a suppressor on your long gun, but you'll only be able to bring in an expert to talk about that specialized knowledge if you are able to demonstrate you actually possessed that specialized knowledge at the time. At the time you use that suppressor mounted gun in self-defense. So make sure you document that knowledge beforehand. Let's see. E Honda, thanks for the super chat. He says, I run a Second Amendment YouTube channel live in Colorado, do live chats. What does a guy got to do to get an interview? Just email us at support@lawofselfdefense.com, or maybe, hold on a second. Let me ask a question. All right. Emily tells me that she already answered you. So you might want to look for that. But what? Okay, so Emily tells me on lawofselfdefense.com, our homepage is a media tab there, and that has instructions for contacting us if you'd like an interview or something like that. Man, every once in a while I pause, and there's really good questions in the non super chat comments, folks. But I would be here for a week answering all of those, so I just have to focus on the super chats. Sean, thank you for your super chat. He says, please do this again. Well, I'll look at the feedback after we're done, and if it's positive, I'm sure we'll do that. Terminal Waltz, thank you for your super chat. Says, I've heard it's unwise to carry both OC spray and a firearm because using spray is escalation of the gun need be used. You carry both. Yes, I carry both. I think that's poor thinking to think it's a mistake to carry both. You want to have more. I mean, if you're only going to carry one, then you're choosing either OC spray or a gun. If you need a gun for that particular problem, OC spray is not the answer. On the other hand, you don't only want to have a gun because, if you look at the Department of Justice crime statistics, you're 5 times more likely to be threatened with a simple assault or simple battery, a non-deadly force attack against which a gun is not an appropriate response, than you are a deadly force attack. So if the more common attack is non-deadly against which a non-deadly response is appropriate, I want that non-deadly response. So I want to have the option to go to the pepper spray, not feel obliged to go to the gun. Now, does that mean a prosecutor might argue if you go to the gun that, hey, it wasn't really necessary for him to go to the gun, he could have used his pepper spray? Sure, a prosecutor can use that argument. But if you went to the gun under the right circumstances where you actually were facing an imminent threat of deadly force harm, you've checked the boxes, and that's what your lawyer will argue to the jury. If those boxes are checked, you're legally privileged to use deadly force in self-defense. You're not obliged to use non-deadly force if you're facing a deadly force threat. Boom, boom, boom. Scroll, scroll, scroll. Let's see. SK Whiskar argues, I assume you feel the same about 3D printed Glocks as suppressors. I'm a Second Amendment absolutist, so I think everyone should have a 3D printer capable of making firearms. I think all the gun laws preemptively applied to law-abiding, mentally sound American citizens are facially unconstitutional. Now, I'm not king, so if you violate a gun law, expect to get prosecuted for it. And if they can put you in jail, they will. So these laws, as unconstitutional as I believe they are, have real effect in the real world. I'm certainly not telling you to ignore these laws. I guess I would say, when I talk about discouraging people from picking an odd means of self-defense, and that would really include 3D printed Glocks, even like 80% Glocks that you finish yourself, 80% firearms, I would prefer that you take a more boring, standard, normal approach. Just buy a normal Glock or buy a normal AR and use that. That said, if you don't have the option to do that, and the 3D printed Glock would be lawful for you, you work with what your options actually are. And if that's what your option actually is and it's lawful, then I guess it's reasonable under the circumstances. But if you have a more boring option, I would prefer you take the more boring option. And just keep stuff like 3D printed guns as fun guns. most of us have 1 or 2 guns we might carry for personal protection and own a lot of other guns too. The other guns are for fun, and I don't really care what you do with those. Modify the triggers, do whatever you want with them. It's fine with me. If all they're used for is competition shooting or plinking or fun at the range or whatever. But my concerns are only with guns that you might use for serious social purposes. Those are the ones I want to, I would prefer be as boring as possible. All right. Well, I think that is all the questions. All right, folks. So I will wrap up. It's been 2 hours and 17 minutes since we went live. I'll review more of the general comments afterwards when I have some more time. And if things look generally favorable, so feel free to put favorable comments in. We'll think about doing this again tomorrow. We'll make a decision about that this afternoon and post up, the notice on YouTube and via email and so forth, and let everybody know. So perhaps we'll be back tomorrow, same time, 9 a.m. Mountain Time. Perhaps not, but in any case, I hope you found today enjoyable. And before I go, one last chance, because this sale is for today only. This Rittenhouse bundle are 4 best-selling online courses, normally $500 for these 4 courses. Get them for $200 today. They're not DVDs. This is online streamed access. The benefit is it's instant access, so you don't have to wait for stuff to arrive. It's our full day course, which is, if it were DVDs, it would be a 4 DVD collection. It's 8 to 10 hours of content. The state-specific content of your choice, whatever state you prefer, defensive property, dedicated course on that, and defense against riot, looting, and arson, a specific course looking at the unusual dynamics of those mob kind of events. All 4 of these for only $200. Save $300, 60% off today only at lawofselfdefense.com/bundle. Today is the opportunity, folks. And with that said, until next time, of course, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill. My family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law so that you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.